Hello, my name is Sophie, and today I will provide an introductory instructional video explaining how your business can ensure that any intellectual property produced for your business, that the ownership will stay within it. A business produces many different pieces of intellectual property in their day-to-day runnings. However, I'll only focus on 4 main pieces in this video: manuals, photos, videos, and logos. Each of these have different protections under the Copyright Act, which I will cover. However, there are other types of copyright work that I will not cover in this video, these including dramatic works or artistic works, specifically sculptures or paintings. When considering the copyright of a manual, it would be considered a literary work due to the written instructions. Section 2 of the Copyright Act calls a literary work any work other than a dramatic or musical work that is written, spoken, or sung. The copyright protection for a literary work is the life of the author and 50 years after the death of that author. A photo qualifies as an artistic work under Section 2, subsection 1II, which includes a photograph irrespective of the artistic quality. In this sense, any photo the business produces will be protected under copyright law. This will be the same treatment as literary work, where the protection duration is life and 50 years after the death of the final author. However, a compilation of images will qualify as a literary work, not an artistic work, which is a point of note specifically in regards to illustrative manuals instead of written manuals. A video produced by a business can be broken down into both sound and film recordings itself, which qualify as their own piece of work. The copyright protection duration of a sound and film recording is only for 50 years from the point of which it was created. Finally, logos qualify as a graphic work, which are covered under artistic work, which give protection of life of the author plus 50 years after the death of the final author. As shown in Johnson & Associates vs. Bucko Enterprises, the logo can be of a purely functional subject and still be protected. When looking at the treatment of ownership between an employee, an independent contractor, and an employer, it is important to understand and acknowledge the difference between an employee and independent contractor. An employee is someone who works directly and exclusively for the business, while an independent contractor is someone who works separately from the business but will be contracted in to help with specific projects or tasks. The key sections that decide who owns what for an employee work is based on Section 21, subsection 2. However, when deciding what an independent contractor owns is decided under Section 21, subsection 3. If an employee creates a manual, takes photos, or creates a logo for their work, then the employer is the automatic owner, but there is the potential to contract out of this agreement under Section 21, subsection 4. However, a video is not recorded under Section 21, but Section 5, subsection 2b does note that the author is the person by whom the arrangements necessary for making the recording of which are undertaken. This means that the employer not only becomes the owner, is also now the author. While under Section 21, subsection 3, an independent contractor has been hired to make the following works, becomes owned by the commissioner, which is your business. These works include photographs, computer programs, artistic works, as well as film and sound recordings. What is notably absent are literary works. But Section 21, subsection 4 does enable your business to contract out of Section 21, subsection 3, and become the owner of literary works. So when considering our previous examples, a photo, video, and logo will be automatically owned by the business who commissioned the work under Section 21, subsection 3, but the manual will not automatically qualify as being owned by the business. But in this case, it is best to state ownership of any literary works and contracts which follow Section 21, subsection 4 to prevent disputes over ownership. Overall, it is beneficial for your business to have copyright ownership in writing before the commencement of any work of an employee or independent contractor for preventative measures. by having a note on ownership of copyright in employment agreements makes the employee aware of the business's intellectual ownership rights to help create a paper trail of who the author and the owner of the copyright material is. While it's even more imperative your business establishes copyright ownership before getting commissions done with an independent contractor, as it prevents miscommunication and confusion that has the capability to lead to court cases, so ownership of a copyrighted item can be established. Due to the lack of register, it is imperative and a lot more cost efficient to have any copyright ownership stated in contracts before any commencement of work with independent contractors or employees. Thank you.